Ryan Brown here from J. Ryan Brown Law. Today we're going to talk about probation violation hearings and kind of how you get there, what it means, and what can happen. Okay, a lot of time, almost every time someone's convicted of a crime, there is a sentence that involves probation. Okay, whether it's all probation or some period of time in incarceration followed by a period of time on probation, there's almost always probation when someone is convicted of a crime. Probation is not always fun. There are strict rules about what you can and can't do on probation, and all too often people face violations of probation. What that means is that the probation officer has filed a petition to revoke probation, right, in superior court or state court if it's a misdemeanor, but oftentimes in these felony cases, we're in superior court. And when the probation officer files that, there's oftentimes a warrant issued for the arrest of the probationer, and they're taken into custody. And it's difficult oftentimes to get a bond on a probation matter, although in coronavirus times people are getting them more often. But eventually, there has to be some sort of resolution to the alleged probation violation. There's a couple ways that can turn out. If the defendant agrees that he violated probation, then he can stipulate that he in fact violated. He can do that via a blind stipulation or a negotiated stipulation, and there's more about that in a separate video about negotiated versus non-negotiated pleas. If he disagrees, or he or she disagrees that he or she violated probation, at that point there would be a hearing. Okay. And there's some important differences between a probation violation hearing and like a jury trial on the underlying offense. So if you're arrested for a crime, you can demand a jury trial. You can have, in a felony case, you can be tried by a jury of 12 of your peers, right? And the prosecutor has to prove that you committed each element of the crime beyond a reasonable doubt, right? An incredibly high burden. On a probation violation, the prosecutor's job is way easier, okay? First of all, we don't get a jury, okay? All we get is the judge. So we get one person, one judge who's already seen you before and has likely sentenced you in the past. And it's hard for them to forget that. Additionally, the prosecutor does not have to prove anything beyond a reasonable doubt, okay? They only have to prove that you violated probation by a preponderance of the evidence, which is typically it's more likely than not. So you're talking like 51%. So it is much harder to prevail as a defendant at a violation of probation hearing than it would be at maybe a jury trial or something like that, because the standard is lower and we don't have the opportunity to have jurors, right? Now you still have the opportunity to cross-examine witnesses. You can still subpoena witnesses to the VOP hearing. You can still testify if you would like, things of that nature. You still have the ability to contest the hearing. It's just in a much different setting, and the government bears a much lower bar in convincing the judge that you violated. So if you're facing a violation of probation hearing, please call us or text us or email us, whatever it may be. You can find us on the web at jryanbrownlaw.com, and you can always call us or text us at 470-635-1725.